and the copyrights are the areas where we practice most of our laws. We have about 375 to 380 attorneys. We have patent lawyers and the technical consultants as well. So in total, we have about 600 to 700 people, including paralegals and the secretaries. We have about 1,200 to or 1,300 people. So we are one of the largest IP law firms in the world. So when it comes to IP, we deal with all the areas related to IP, and these days there are many litigations related to IP, and we are quite famous for the IP litigation, and we have been representing Korean companies for a long time, and we do have attorneys at our law firm that can speak Korean, and we deal with many different technology areas. And then I would like to introduce to you why ITC is important for Korean companies. You seem to have forgotten to introduce yourself. You may need to, you have to introduce yourself as well. I've been living in the United States since my college days. My name is Chanho Sonu, same as Chano Park, the baseball player. So I have been living in the United States for about 40 to 45 years. But I did serve in the Korean Army, and I've lived in Korea since then. And I do have families, my brothers in Korea. So Korea is my mother country. But I have been living in the United States for a long period of time. I studied electrical engineering. I worked as researchers as well as a lawyer at DuPont and IBM, and I've been working at Finnegan for about 23 years. If I may add more, Mr. Chano Sonu has been representing many Korean companies, and especially when it comes to IT, he has has many in-depth insights, and so every year with we have been operating a cooperative project with a KEA, and he has been providing many advices to Korean companies. With Judge Essex and other prominent attorneys have been invited today. And also Mr. Chano Son, as I said, had a lot of affection for Korea and its companies, and that's why we have and hope that he will continue to provide us much support and assistance in the future. Please let's give Mr. Sonu a warm round of applause.
Yes, we do have such distinguished people with us to talk about the issues concerning IP, and the information transfer is what I am doing right now to those of you here in Korea. Thank you very much for that praise. Now, shall we start? Today, some of you here have been involved in litigation in the US. I know a lot of you might be very familiar with that, or some of you might be, this might be your first exposure to these aspects. So because we have many diverse levels of expertise and knowledge, I'm going to assume that we are all at the beginning level. So please, I would like to ask you to understand that. Also, in terms of proceedings today, because I do know Korean, I will be using Korean, and the others will be using English, and we'll be having interpretation. In terms of questions and answers, because of the time limit, please, we had planned for a Q&A session at the end, but during the process, if you have questions, you could jot down your questions in a paper, and maybe you can send them to the organizers as you get them. Also, in addition to the judge and the attorneys, because they actually practice what we are hearing about, anything that you are concerned about, not only in theory, but also in practice, if you have any questions, I think it would be very chance for you to directly converse with them. First of all, I'd like to talk about the litigation issues and about the system itself, although it's not in your booklets. We have these ITC patent litigations. They occur at the ITC and also at the judiciary system. Today, concerning the ITC litigation, ITC I have not prepared because Judge Essex and Mr. Jarvis is going to deal with that at length afterwards. However, in terms of the judiciary system, it is quite different from that of Korea. When we have a litigation in terms of IP, any kind of violations or the validity of a patent, all of that will be decided in court. We don't have anything such as going to the patent office and getting confirmation. That's not the case. And so the judiciary department will have jurisdiction, and there's also the case of the ITC. And in some instances, the ITC and the judiciary system will deal with the same thing. It might be the same complainant and the same respondent. So they do take different courses of action. In that case, why does ITC have to deal with these issues if the judiciary system can take care of all of that? Well, the goal of setting up the ITC as part of their trade policy, any kind of imports from overseas, if a domestic U.S. company receives any damage, ITC is set up to speedily resolve that kind of problems. What that means is that they're going to exclude the import of such products. So ITC can deal with exclusion orders. And in the judiciary court system, it is very complicated to have a ban on the import of goods. So the ITC can do it in a more speedy manner. And so from the complainant's perspective, because it is speedy and because it is effective, they make use of the ITC system. And the imported products could be the product of a competitor, and that can give a big, that can have big impacts on the market itself. That is why the ITC has been involved in these patent litigations. But recently, we are seeing more and more of these cases coming to the ITC itself. But when they say they're protecting the U.S. firms, what does that mean? It does not necessarily mean a company which has a name such as IBM or Coca-Cola or DuPont, not only the domestic American firms, but also, if you invest in the U.S., invest in facilities, if you conduct research in the U.S., if you have R&D activities in the U.S., even those companies can be presumed to be a U.S. firm. Therefore, Samsung Electronics, as a firm in the U.S., in the past 5 years, Samsung Electronics has, in some instances, acted as a complainant to the ITC, and there has been 4 cases in the past 5 years. Because Samsung Electronics has a factory in the U.S., and although it's a Korean company, it's not the case. You might think that Samsung Electronics is a Korean company, but in some cases, it's presumed to be an American firm because it has a presence in the U.S. Also, a Korean company can also raise litigation activities against a Japanese firm as well. So that's what is going on. Now, even with the ITC litigations, they could go to the judiciary system. And the reason for that is that the ITC does have the authority to ban imports, but they do not have the authority to give any damages. Therefore, if the patent holder wants to have any damages repaid, then he has to go to the general judiciary system. So that is a reason for these dual kind of litigations. So today we're going to talk about these issues, but today we're going to deal exclusively with ITC areas. And also our judge here, Judge Theodore Essex, is his position is different from the general judicial courts. Once you become a judge at the judicial court, you hold that title for life. But in the case of ITC, the term is for 7 years. Also, the ITC judges, most of them deal with patents, and they're very much specialized. And because of this 7-year term, they work even harder, I believe. But also the federal courts, the judges, because in some instances they may be involved in patents, they may be involved in murder cases. They have a great variety of cases to deal with. So in some instances there are experts, but on the contrary, the ITC judges are very experts, are very much specialized. Also, if there has been a decision reached at ITC, or if there is a decision in the judicial court, in the U.S. there is a federal circuit. The U.S. FCCA is the only place where you can raise appeals. So this has been the background for my introduction. Now, in terms of ITC, why is the ITC becoming so important to the Korean companies? So I've tried to look at several numbers in the past. Now, looking at these numbers, in the year before the year 2005, there were about 3 litigation cases, and those were involving the Korean companies. But in some instances, the same company may be involved in 1 or 2 or 3 cases. But since 2005, we have seen a drastic increase in the number of patent cases. And according to this number, in the year 2009, we had a bad economic situation. It went down slightly. But if you see here, in the year 2008, we had 10 cases.